My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to talk about property divisions and how one can protect their property. It's designed to educate the public, so please subscribe to our channel. You know, people will call up all the time and they'll say, look, I know that when I get divorced, I'm going to have to split stuff with my ex, but I really don't want to. How do I avoid doing that? And really the question is, what does the word my, or the two words my stuff, actually mean? If by saying I want to protect my stuff, they mean stuff that they brought into the marriage, prior acquired property, things that were accumulated in their youth or given to them as an inheritance all before the marriage began, the good news is I'm here to tell you that there's ways to protect it. I mean, you know, the court can be made aware, motions can be filed to establish that certain property is separate, it's not subject to division. The presumption of the court is going to be that everything that you got is in play unless the court is told otherwise. So there have to be findings of fact that certain property is just not part of the marital estate. This is something you should bring to your lawyer's attention. It should be something that there should be a discussion about, and you have to understand a couple things. Number one, what you think should be property that's separate may not be according to the law, and what you think is at risk may be separate property. So you've really got to have your attorney go over these things with you and tell you what is separate and what is not. You have to remember one thing. Ultimately, the decision is going to be made by the court as to whether or not this is separate property or marital. The court is going to look at some sort of fundamental fairness in order to determine that. So if you can find a mutually acceptable resolution right off the bat, obviously that's going to be the best thing. But you need to understand that the court is going to try and be equitable, try and be fair in approaching the division of assets. So for example, if you have a 401k plan, you got 30 years into the plan, but 23 of those years were before you got married and 7 of the 30 are after you got married, then really only 7/30ths of that plan is in play. You need to let your lawyer know that the contribution to that asset occurred way beforehand. So therefore it can be limited to only the marital portion. If you don't make that known, everybody's perception is going to be whatever you got now is in place. So you've got to be very careful about those kinds of things. Really, again, there should be open communication regarding the assets, regarding when the assets were acquired. And remember what I told you before about fairness. If the parties, for example, bought a house and the house is in the husband's name, and it was bought a week before the marriage, and then the parties moved into the house, and the parties lived there for 20 years during the marriage, you're never going to be able to convince the court that that asset is not in play because it was purchased before the marriage. Even if it's in your own name, the court's going to say, you know what, both parties put a lot of time into that house. That's the marital home for 20 years. There's no way that the court is likely to say, oh, well, I'm sorry, you know, we're going to start making calculations and stuff like that. On the other hand, on the flip side, if you bought the house 10 years before the marriage and then they moved into your place and then there was a short-term marriage and a divorce, the court's not likely to find that that's a marital asset. So you see, the court's going to approach it with a view toward fairness, a view toward what's equitable. Now, if you have any questions about what's equitable for you, reach out and we'll be glad to help you out.